Philip, I'm turning to you now. I'm really interested in what you have to say about the prosecutor's closing.
No, I listened. She was a little flat for me, but she got her points out there. But what she did establish, though, is that this was no accident or misfortune. The legal definition of accident is basically an unfortunate occurrence without evil intent or culpable negligence. And we know that, of course, that this was unfortunate, and they're declaring it to be an accident, but they're also saying that this act was done with some type of criminal negligence. And I think they established that. Here you have a taser that has a different weight than the service revolver, has a different color, it's carried on a different side of the body. She's holding it out there, pointing it at Dante for 5, 6 seconds and deploys it anyway. A reasonable jury might say she had it long enough in her hand to catch those distinctions in her peripheral vision, and therefore this was no accident, this was no misfortune, this was reckless and culpable negligence.
All right. Well, apparently the jury is wrestling with this because they've been out for some time. They deliberated yesterday, Monday, and now they're yet again deliberating today. So they've been at it for a little while now. Let's listen to a little bit more of Aaron Eldridge's closing argument, and then we'll discuss it on the other side. Interesting. Philip, do you agree with Janine on the cross-examination of Kim Potter by Aaron Eldridge?
Yes, I do, to be quite candid. Now, they did have a very pedigreed police psychologist who explained the whole, weapon confusion phenomenon and the slip and capture phenomenon. And if the jury accepts that testimony, then what that will do is it will negate the criminal negligence, and the jury can find that it really was just a misfortune without any evil design, without any intent, and certainly without any culpable negligence or reckless conduct on her part. She came off as a very likable, relatable, sympathetic soccer mom. I mean, look at her there. She doesn't look like a decorated cop up there. She looks like, a very fallible, fragile mom to whom this could have happened like anybody else. It's just a tragedy.
And I think that part of that was designed. And you're right, it is a tragedy. It's awful. And I am sure she feels terribly about this and wishes she could undo all of it. And it was hard to watch her on the stand like that. I think that's part of the reason they put her in that ensemble too. It makes her look kind of matronly as well. I'm sure that was by design. So let's look at a little bit of the closing argument by Earl Gray. Earl Gray represents a lot of police officers. He's one of the dozen or so defense attorneys rather in the state of Minnesota who represents police officers in cases like this one. And he's always very interesting. He provides us with some entertainment, but this is a little bit of his closing argument. And that was Earl Gray making the case that Kim Potter, as he told the jury, he says she's not just not guilty, that she's innocent. That is part of what he said yesterday. And I thought he made an interesting point there. He questioned, Philip, and I'll throw this one to you, that how can you recklessly handle a firearm if you don't know you have it? Does he make a valid point there?
I think it's genius, frankly. Right? You're not consciously handling the firearm in that stressful situation. The problem is, you have with law enforcement in any civilized society a social contract with the community. She was supposed to be a leader. She was supposed to be a supervisor. And if you don't know what type of device you're carrying, even in a volatile situation like this, you come off looking like a rookie cop, and you should not be in that job. Now, she's not to be judged because of her leadership abilities. I think the real question for the jury is going to be, was she under a stressful enough situation where she lawfully and permissibly confused that weapon for a taser? And if so, it didn't rise to recklessness and it did not rise to culpable negligence. What you have really is an unfortunate act that was not accompanied by the criminal mind that is required under the law. You must have that culpable mind attendant to the criminal act. If she didn't have the mind and all you have is the act, that's reasonable doubt.